So I'm Alison Cole, I'm a trademark attorney. I'm going to talk about keeping your brand safe before and after Brexit. There are Brexit implications, sorry, I don't know if you can hear. There are Brexit implications, not as severe as some of the issues you've talked about today, but just generally talking about protecting your brand. And then once I've given the sort of theoretical part, then Jet's going to talk about the practical part of protecting counterfeits, primarily online. Just as a show of hands, how many of you have, or in your companies have registered IP protection trademarks, patents, designs? Okay, so you'll probably understand quite a lot of what I'm talking about, but this is just a little bit about the firm. The important point at the bottom is, in terms of today's talk, we've secured IP rights in 180 territories. Intellectual property rights are territorial, and at the moment you can protect a European-wide trademark and a registered community design and a European patent. So that's where the Brexit bit will come in, and I'll talk about that in a little while. So I'm going to talk about the different types of IP, what, when, how and where to protect, and then how to enforce your IP rights in the most cost-effective way. So the main reasons for protecting your rights are to preserve their value, to stop other people from counterfeiting, and then to control and exploit and maximise the investment you've put in your creativity. So that might be by license or franchise, through the ultimate sale of your business, through collaborating and licensing with other brands. There's quite a lot of misconception about what is protectable and what isn't, what's an enforceable right and what isn't. So what is not an enforceable right is a company name, a domain name, any social media handles, and the ideas themselves. It's the expression of those ideas that you can protect. Those things are useful, and if you can't get a company name or a domain name or a social media handle because someone else has got the one you want, it's a pretty red flag that you shouldn't be using that. There are some exceptions, but that's a pretty good rule. But there are lots of things that are enforceable. So there are automatic rights, which are generally unregistered. They are more adaptable to changes in technology and to economics and how a marketplace might work, but they are much more expensive to enforce because they just exist, and therefore you have to prove that you own them before you can enforce them. Whereas with the rights on the right, you need to take action to own them, but then your ownership of them is recognised at the beginning of any enforcement proceedings. So the automatic ones are copyright, design right, and an unregistered trademark. And I've put up there because, again, it's something that a lot of people aren't sure about. If you think something is a trademark, you can put a TM beside it. You are holding yourself out as thinking it's a trademark, so if someone else comes along and says it's theirs, you can't say, well, I'm not using it as a trademark, because you clearly are. You can only put the R in a circle once you have a registered trademark. And then the own name exception, nobody can stop you trading under your own name, but that probably won't extend to a company name. So with the Jo Malone example, she traded under her own name, nobody could have stopped her anyway. She has sold that to Estee Lauder, so she now can't trade. She can still be called Jo Malone, but she can't trade under Jo Malone, so she now trades as Jo Loves. The Harrods one is up there because you also can't change your name to a well-known brand and get away with it. So there was a man who changed his name to Mr. Harrods and tried to open a grocer's shop. It didn't work. So your patent is your invention. It could be something simple, mechanical, like a new way of fastening a coat. It could be some anti-counterfeiting technology like RFID tags. It could be some use of blockchain for tracking a product's lifespan. But it must be an invention, it must be new, it must have an inventive step, so not to be obvious. The impact of Brexit is zero. There is a European patent, but that's a European body, not an EU body. And I think you had I don't know if that talk explained that today. So if you have a European patent, nothing will change, it will still cover Europe. So trademarks. These are generally known as soft IP because they're a little bit easier to get. The requirements are not quite as high as a patent. But also, because you can maintain them indefinitely, and they're fairly broad in terms of what you can protect. They can give you a great deal of protection for your money, whereas a patent and a design are limited in the number of years that you can hold them for. So trademarks, you can protect words and names, letters and numbers, so OIA would be protectable, logos, slogans, shapes, so maybe a distinctive knife or a distinctive piece of climbing equipment. If it's recognised by the average consumer, then that shape might be protectable as a trademark. Colours, so you have the red soles there, that has been protected as a trademark. Sounds and graphics, which I'll come on to in a minute. We're also seeing a lot more companies trying to protect experiences. As I said, you can't protect an idea, but experience is something that's driving retail back in store from online. And there are different ways, with a bit of creative thinking, that you can protect what you're doing to get people back buying the product in the store. So I've got a few examples of more unusual trademarks, and I hope this is going to work. So the top left is a cheddar cheese in a burgundy wax in a heart shape, and we have protected that for a client of ours. We had to show evidence that it had become a distinctive thing that people asked for. So it can be a bit more difficult to get an unusual trademark registered, but now they have the exclusive rights to use that. It's pretty restricted, but that's what they've got. Obviously, the Apple symbol is pretty straightforward. That's an example of a logo. The top right turquoise box has been registered by a bank. Anybody, any ideas who might? Yeah. So Barclays Bank have the exclusive right to use that colour turquoise in respect of banking services only. And similarly, the one underneath was orange for telecoms. I don't know if anyone remembers, it's sort of age showing. They started out with just big orange billboards. Yes, it has to be, yeah. There are registrations that have been got without Pantone colours, but the result of the Louboutin red sole shoe case was that you really need to put a Pantone colour, or a lot more than just the colour red. It's not enough anymore. And similarly for the burgundy heart, there was a Pantone colour. You can also register graphics. If you look at that one, that graphic has been protected by Castrol. There are two sound marks here. I don't know if anyone can read music well enough to know what that one along the...
trying to comment, but I found...
Okay, so this might help. So that's the Direct Line jingle.
That's what it sounded like.
And then this one.
Simples.
That's the Meerkat. So that's a client of ours. We've protected that as a sound mark. So, as I say, if you're creative, there are lots of different things you can protect. It can be more difficult to do, but if you've got evidence that that's how people recognise you, then generally you should be able to get protection. Okay, good. So, in terms of what you can and can't get protected, for a trademark to be protected, it's got to be distinctive, not descriptive, and not generic. And it mustn't be identical or similar to anybody else's earlier marks. And the tests are fairly broad, depending on how distinctive your mark is. So whether or not there's a likelihood of confusion, any unfair advantage, dilution, that kind of thing, or any passing off. Usually it's very case-specific as to what needs to be shown and how similar or unsimilar, dissimilar the marks or goods need to be. But that is the law, and it's all set out, obviously, on the handout. When you're talking about goods and services, they all fall into one of 45 classes, and that helps to distinguish different companies' activities. So you've got the three examples there. You have Polo is the trademark. It's registered in class 12 for cars, in class 25 by Ralph Lauren for clothing, and in classes 29 and 30 by, I think it's Roundtrees that make the sweets now. So that helps to... It's not a definite rule that if you're in a different class, you won't infringe somebody else's rights, but it does give a good idea that consumers will probably see you as doing something different. Again, it's something that needs to be looked at with the changes in retail and the changes in how things are marketed, because, for example, a trademark that currently covers retail services doesn't cover unless it's in a different class as well, rental. So if you were previously selling something and now you're renting it, because that's a big thing in the clothing industry, for example, you need to make sure your trademark protection is covering you in both classifications. In terms of Brexit, the UK government is going to provide an equivalent cloned right of any registered EU trademark. So if you have an EU trademark now, which everyone has had for the last 20 years, because it's the most cost-effective way to cover all 28 current member states, what will happen is that will be cloned and put onto the UK register. A lot of companies have both anyway, but if you don't, it will be cloned and put over. If you've got a pending right and it isn't registered yet, that's where we don't know. As lawyers, we hate saying we don't know, but we don't know. Probably you're going to have to reapply. Probably you won't lose any rights, but it definitely will cost you more. And it will cost you more to have the cloned right because you'll have to renew your EU right and your UK right. There are also technical issues to do with where you use your mark, but they are technical. So if anybody's got any queries, please ask me afterwards or contact me and I can happily help. So in terms of designs, that protects the appearance generally of an item. So again, there, as I say, React for Compare the Meerkat, and they're the three different designs that we've protected for their different toys. It can protect ornamentation, decoration, the whole or part of a product. Again, like patents, it must be new and it must have individual character. So that's a lot more strict than what you can get away with for trademarks. It protects against substantially similar products, and as you'll see from the next slide, it really does have to be very close. The big case that surprised most people was the Trunky case. The far left picture is what Trunky had registered, the middle picture is what they used, and the far right was deemed not to infringe because the far left, for example, the wheels are shaded a different colour to the body and it doesn't have the same antenna, and that was enough. So you have to be really quite close to infringe a registered design. In terms of Brexit, the impact is the same as trademarks. There will be a cloned registered design, so there will be the additional renewal costs. We also don't know what will happen with pending registered designs. However, a registered community design is usually granted within about a week of filing. So even if we go out in 10 days' time, 9 days' time, you could still file today or tomorrow and you probably would get it registered. It probably still wouldn't be pending, but do it quickly. So this is an example of the kind of comparison that takes place between infringing and infringing and counterfeit or copy items. So you can see the level of detail they have gone into between the genuine product, which is on the right, and the infringing product on the left. It was, in that case, held to infringe. But there's a lot. It's not just looking side by side or with the products apart. So copyright is the automatic right. As I say, you don't have to do anything to register your right. It either exists or it doesn't. It has to be an original work that's involved skill, judgment, labour, selection, and not be copied, derived from or adapted from an existing work. It arises automatically on the creation of the work. It can be registered in the US or China and one or two other countries, but generally it's not a registered right. It's something that, as I say, exists or not. And it's a negative right. It doesn't give you a right to do something. Unlike a trademark where it gives you exclusivity, a copyright is more to stop anyone else from copying you. So it's a balance between remunerating the creator versus they want people to use it, but in a restrictive way so they maintain the value. So copyright, it's a very tricky one. It's one that actually is quite useful because if anybody has taken any part of your website, possibly including your terms and conditions, although whether or not there's any skill or judgment that goes into writing them is debatable. But it's the one that's usually used because people are lazy and they try and pinch things and put them elsewhere. Hello.
Quick question on that one. The one about the employee.
Yes.
I just have a vague memory of this. When I owned that equipment, one of our designers used to put the little C, copyright, and then she finished. And I seem to remember we asked them to stop doing that because there was some risk that she could leave the company and go to work for Berghaus and would then own copyright designs that we paid her to do. Isn't it?
Was she an employee?
She was employed
Then
by us,
no,
but she
no.
didn't put this on everything she did, and she did some work at home for us. But
Right, okay, so the work at home can be a little bit ambiguous, but provided it's something you had asked her to do, if she chose to do it outside of work hours, it was still for you as an employee. The tricky situation can arrive when you've got contractors or if you're using designers that are external to the company, then you have to make sure that you own what they have created. Usually it's in the contract, but of course an awful lot of things are done without a contract. But it's fairly straightforward to sort out afterwards. But putting the C in a circle just says there's copyright in it. And again, it's a bit like putting the T in. You're pointing out to people that there is copyright content. So I'm not really sure why. But copyright is a difficult right to sort of get your head round and difficult to enforce, and so there are lots of myths. Same with design right. You may have heard if you change 5 things you won't be infringing it. That's rubbish. If the essential part of the product is still there, if you're conceived to have copied it, derived from it, or adapted it, you will still be infringing the copyright. So yes, the owner is the person who creates it, except the employee when it is the employer that owns it. Yeah, it's got a restricted lifetime. So things, old pieces of music that you now see being covered an awful lot, it's probably because they've come off copyright. And the length of it depends on when it was first created and what kind of work. There are different lengths of copyright, whether it's artistic, photographic, literary, and again, any specific questions I can answer afterwards. There's no effect by Brexit on copyright. So copyright is infringed by anyone who reproduces, distributes, or carries out a performance. So there is copyright in a live performance as well. Best practice is to get consent. Now this is something, I'm only going to skip over it because we've got quite a lot to get through, but it comes up quite a lot with social media now. If you reuse a meme or any other kind of graphic that you find online, are you infringing the copyright? So the best practice is to get consent. If you can't get consent, and often you can't because you can never find the source of it, then at least acknowledge that perhaps it wasn't yours. There are exceptions that allow you to use copyright, but they're generally, again, fairly restricted. You can use it for research purposes, for teaching, and in domestic use. So any non-commercial fair dealing, you might be okay. So as I say, these are different types of use where copyright exists and is enforced quite a lot at the moment. The photograph and images, that was quite an interesting case because it's a picture of Gigi Hadid, which was taken, the left one was taken by just a paparazzi photographer. The right-hand one, she reused it, but changed the logo on the bag to promote something she was promoting that day. And the paparazzi photographer sued her for copyright infringement because he owns the copyright in the photo. Whether he would have gone after her if she wasn't a multimillionaire, I don't think he would have done, but she has fought it because she said there's no skill or judgment in the photo that he took. It was just a snap. It's ongoing. It's in the States. I'm not really sure, but I'm not sure the legality or even the necessity to have a court case over it. However, it's just a warning. If you don't own it, you do need to sort of be a bit careful. You also have to be a bit careful about buildings. So the Vessel, which is part of Hudson Yards in New York, there's an automatic agreement when you go onto their premises that any content you post, they own and can republish anywhere they like. So I don't know whether that applies to any of the environments that you're using your brands in, but again, it's just something you have to be a little bit careful about. User-generated content is something that we get asked about. If you're asking people to post pictures online with your product, you still need their permission to reuse. Now, you can either contact them directly and say, can we use the picture you've just posted, or you create a hashtag just for that promotion, which implies that they've given you consent to reuse. The other things I think are fairly straightforward. So when to protect your rights? With patents and registered design, as I said, they have to be new. So once you've disclosed them and made them public in any way, they may not satisfy that novelty requirement, so you might have lost your possibility to protect them. So you register first. Copyright is an automatic thing, so there's no timing issue on that. With trademarks, it's a bit more difficult, depending on what you're protecting. Ideally, you should protect it before you start trading, because you don't want to be closed down straight away for infringing someone else's trademark, and you don't want someone else to copy you immediately. However, that's not always feasible, but depending on your business, you might do it when you get to a certain level of sales, a certain amount of investment or profit, but equally it might be a number of social media followers. The reason I put China there is that if you are even thinking about having anything manufactured in China, register there immediately, because it is not seen as bad business practice for someone in China to register for you and then withhold that registration from you unless you pay tens of thousands of pounds. And they can then stop you from exporting your goods, because exporting is an infringing act. So you can have your goods stopped at the port because somebody else owns your trademark registration. It's done all the time. So as I said there, being proactive and getting yourself protected, although it is an investment, it isn't the cheapest form, it's certainly a lot cheaper than having to be reactive. And as Dan said earlier, you have to be ready to react. And that involves having all of your IP protected. Once you've got it protected, like any piece of property, any asset, you need to maintain it. So this is just a quick checklist of things you need to do. Policing and watching on the marketplace and on the registers, you should probably have your brands registered with Amazon Brand Registry. But in terms of the rest of the monitoring bit, I'm going to hand over to Jet in a minute to talk about that. We have in the past acted for Thermos and Hoover, which are not generic terms, even though they are frequently used as such. They have very good policies in place for writing to anyone that they find using it in a generic way. It doesn't stop everybody, but it does mean that they can still enforce their trademark registrations. Nowadays, with social media and communications, you can also get your consumers to be engaged and report to you when they find out any counterfeiting or close trademark, patent, design issues that they find. I'm not going to go through all of these different ones, but this is if you want to enforce something, traditional litigation route. As you can see, there are a large number of steps to go through, and each one involves an awful lot of cost. There are different ways of taking. There is a special court just for IP issues. And that can be, you can see the comparison there. The larger issues is the multi-track version, and there you've got damages up to £500,000, or you can do the quicker small claims track, and that is quicker, but you won't get your costs back, but you will get a quicker result, which might be more important to your business. It's a very transparent process. There's lots of case decisions that will influence how the case will run. It's very straightforward, very transparent. It should be predictable. We should be able to advise on the outcome of a case. There are a range of remedies, from getting damages or stopping somebody from trading or seizing their goods, destruction of goods. Both parties are involved, so you can defend a claim if someone brings it against you. And the burden of proof is on the person bringing the claim. But it is expensive. And there are now lots of other ways of enforcing your IP rights instead of having to go to court, which are a lot more accessible. So you have online marketplaces, and as I said, Jet's going to come onto those shortly, as well as takedowns on social media. There are other options. For example, if someone has got a domain name that you want to get back because it's infringing, then that's easy to do. It's particularly easy if you have your word protected as a trademark. That's a very straightforward. Same with most social media, domain name, marketplace takedowns. If you have your trademark registered, it's generally unquestioned as to your rights in that, and you are a lot more likely to succeed. I've got a case study on that in a minute. The Brexit impact is important. UK companies won't be eligible to hold .eu and several other country code domain names after Brexit. If that is your extender, then suggest you get a different one pretty quickly.
Well, that's the other way then. What about EU countries taking .co.uk?
That's a UK government decision, and they don't want to put barriers to trade up. Don't get me started on that one, because it's the same for my profession. The alternative options are a lot quicker, they're a lot more disruptive, and therefore can get a lot better results. They're much more flexible, they're much cheaper. However, they are unpredictable because they're not done with any background of any case law. I'll give you an example which explains it a bit. They're unenforceable, so there's usually not a lot you can do if the other person says, I'm just going to carry on. And there's no appeal. So if you don't like the decision, then it's generally hard cheese, but again, you will see in a minute. So one of our clients was on the receiving end of a letter from Amazon, a takedown notice, saying, you've got to take it down. They didn't have to provide any supporting evidence to get Amazon to send the letter. They were given two options to resolve it. Either the rights owner has to retract it, which they didn't do, or our client had to prove that they were not infringing, where you can't prove a negative. It was very, very difficult to do. We're not entirely sure what happened because the client just decided to walk away, whereas we would have perhaps preferred to fight it, but obviously there's costs involved and it's unpredictable. On the other hand, I had a situation where my client was making the product on the left and found somebody making the product on the right. They didn't have a registered trademark. They didn't have a registered design, so they threatened unregistered design rights. Amazon came back initially and said, we want more information, it's going to be complicated, no, we don't like it, we're not going to help you. So the client decided not to go ahead and contacted the seller direct, and they've now gone into business together. So there are other ways of doing things than just going down the litigation or any kind of conflict route. This is a contrast, and I think highlights the unpredictability of Instagram. So we act for Anna Park Limited, who has concrete shops selling clothing, but also has the Instagram at Shopper Anna. She's got the UK trademark registration for Anna and the domain name shopperanna.com, but she didn't have the trademark shopperanna.com or Shopper Anna. However, the two combined were good enough to take down at shopperanna.co, which was a Malaysian account, but only because they were selling clothes and in the English language. So it was enough to get Instagram to take it down. On the other hand, we had a client who had at the Fertility Kitchen and the registration, so she had the social media handle and the trademark, but we weren't able initially to take down at Fertility Kitchen because the owner was based in Hungary, and that particular Instagram examiner said that meant that they weren't accessing the same market. However, all of the posts were again in English. However, we tried again the following week and it was taken down. Exactly the same form filled in. So that's why it's unpredictable. Now that's fine from my client's point of view, but if you're the other person, it doesn't feel terribly fair. So if you're willing to take a risk, then have a go on the more flexible routes. On the lesson, this is a summary of the contrast between the two. Sometimes it's enough just to send a fairly threatening letter. I prefer to start with a less threatening letter because most people either do it, if they do it on purpose, then you're probably going to have to go the whole way. You're probably going to have to take them to court or take some fairly drastic action. But a lot of people end up infringing your rights because they're lazy and they would rather copy yours or get as close as they can to yours than invent their own. You should still take action because you've bothered to put in the creativity. But often when they're called out on it, they actually back down. I made a phone call to a company recently who were infringing my client's rights, and I just said, look, please could you just take those 2 words off your website? Oh, I don't want to, I'm going to see you in court. They were gone by Monday morning because he knew that and there was just no point in fighting it. He'd done it because he wanted some of my client's traffic to go to his website. It's horses for courses, but generally speaking, there is now a lot more options in terms of what you do to enforce your rights. And with that, I'm going to hand over to Jet. That's great. Which way are we going?
Sorry, I'm Jess and this is Mary. We're actually going to be co-presenting this presentation.
Yeah.
So we're both from SnapDragon, an online brand protection company, and we're based in Edinburgh. So delighted to be here and really grateful as well to the OIA and particularly to Andrew for the opportunity today to share a little bit about what we've been learning about online brand protection. SnapDragon provides online brand protection using innovative technology to find and to eliminate brand abuse on the world's busiest marketplaces, auction sites, and social media channels as well. When we started a few years ago, the main issue was around the marketplaces. Everything continues to change, as we've been learning about all day, and now a lot of the copying and illicit actions and unauthorized sellers are appearing on social media channels and domains as well. So we're continuing to keep up with those that infringe IP rights and unauthorized sellers. But we hope today that we'll be able to provide you with some helpful advice, and Jet will come on to that in a little bit to share some of her experiences. The first thing we wanted to do was to talk a little bit about the context of IP infringement and illicit selling on online platforms and give you a little bit of context. The numbers are very big. There is a slight spot the difference there, but I'll come on to that in a minute. I think that was lost in translation from one computer to the next. The trade in fake goods accounts for 3.3% of all the world's trade, and that figure is rising, and it's been rising for many years, and it continues to rise. So the problem's actually going to get worse before it gets better, despite there being many organisations working to tackle it. And the value of the global counterfeiting is not, in fact, $2 trillion US. It was in 2017, yes. It was 1.2 in 2017. But it's expected to get towards the 2. It's expected to get towards 1.82 trillion by next year. So the numbers are phenomenal in terms of illicit trade. In terms of where the goods are coming from, the majority of fake goods continue to come out of countries, as we know, China and Hong Kong. Indeed, about it's 86% of goods that come out of those territories. But other places of origin include the UAE, the United Arab Emirates, Turkey, Singapore, Thailand, and India as well. That's where they start. But where they have the biggest impact in terms of manufacturers are the United States, followed by France and Italy. But that doesn't mean the UK is immune by any stretch. And in the UK alone, illicit trade costs the economy over £9 billion in revenue each year, and that affects almost 60,000 jobs, and there's over £4 billion worth of unpaid tax as well. So it is a huge issue, and there's much to be done. In terms of the outdoor industry, there are so many aspects to the outdoor industry in terms of apparel and gear and so many things, and you represent some of those. And the increase in popularity, particularly of the apparel brands, over the recent years has gone hand in hand with an increase in counterfeiting as well. And North Face, Columbia brands, as well as others, Canada Goose, Rab, and Arc'teryx as well, are some of the bigger brands that have large-scale issues. They have big teams of people working to tackle those, and they promote what they're doing quite strongly on their websites. But that's not everybody's way of dealing with things. But the main thing at this point to emphasise is that it isn't just the big brands that are affected. Counterfeiting and unauthorised selling in whatever form can affect any and every brand of whatever size and whatever the product. Many of our clients that we work with are SMEs, not all of them, but we work with many of the smaller brands who have big issues. So why should we be concerned about any of this? Well, if you've been at the receiving end, you will know. But the main three reasons are that when copycats come on board and copy any aspect of your brand, there are three main risks. One is it will divert revenue from your genuine and hard-worked revenue streams. It will be a potential damage to your brand reputation, and it could also potentially put customers at risk as well. The production and sale of counterfeits, for the first point, has serious economic ramifications for a business. And as I've said, illicit sales can affect revenue streams, but furthermore, consumers, when they experience a fake good, they may probably pick up that it's an inferior good, and often the complaints go back to the genuine brand. And so it's the genuine brand that has to pick up on the warranty costs, and often feels obliged to make the customer happy, make the consumer happy. So they're losing twice. So they've lost the original sale, and then they're replacing the inferior, often fake good or whatever, by compensating the customer. So the costs of the warranty climb, and the faker options puts downward pressure potentially also on the price of legitimate goods. And one of the things that we've noticed in over the last year particularly is that copycats and counterfeiters are not necessarily offering a very reduced price for the item that they're selling, but they're going just below the RRP. And so unassuming customers might come along online and think, oh, that's just a really good deal. So they might get lulled into that and make a wrong decision. As you all know, developing a product and a reputation takes a lot of time. One of the things that I was mindful of this morning as we were in our group discussing the effects of Brexit, I think one of the things that's happened with Brexit, it's diverted so much energy and attention and creativity away from brand owners and people that work within companies to think about Brexit. And so much of that energy and creativity could be putting back into their brands and all these wonderful talks that we've been hearing about earlier today. But the other thing that damages that as well are the counterfeiters. They bypass all of the hard work and make a profit on the back of it. And again, if you've been at the receiving end of that, you will have felt that pain. The products that are produced lack the quality, so all the mechanical testing, chemical testing that a brand undertakes to ensure that it's safe for its end customers is often bypassed. So the goods that are made are, as I've said, inferior, and that can really damage a brand's reputation. Counterfeiters, therefore, make very unsavoury bedfellows, and indeed counterfeiting is often linked to other forms of criminal activity. The counterfeiters really just want to make money, and they don't care, I don't think, how they do that, whether it's exploiting people in working conditions, child labour, or environmental pollution, whether it's human trafficking, modern slavery, or even more sinisterly, terrorism. They're making money on the back of counterfeiting. And that goes hand in hand of the activities that certainly, I'm sure no one in the outdoor industry wants their brands to be associated with in any way. Interestingly, some market research was done with some UK consumers to ask them about buying habits, and 76% of buyers asked said they would be less likely to buy products from a brand if their reputation was associated with counterfeit goods. So that can also impact on genuine sales. So aside from the disappointment of poor imitations, inferior counterfeit items can be extremely dangerous. Low quality paints, glues, dyes are often toxic. Poor electrical wiring can lead to electrical shocks, strangulation hazards, all sorts of things. And in the outdoor industry, when products are relied upon heavily for safety, with many activities, whether it's staying safe and warm on top of a mountain or with climbing gear, safety is the absolute number one priority. And these pictures here just show some crampons, climbing ropes, helmets and ascenders, and in consequences of poor quality items with any of these, the effect could be fatal. So it is a big issue, it's very impactful, but there's a lot of positive things that can be done, and this is where I will hand over to Jet.
Thank you. Thanks, Mary. So I'm Jet. I'm part of the brand specialist team at SnapDragon. So what I do on a daily basis touches a bit on what Alison was talking about, the other options rather than legal action to enforce against infringers is about using these takedown procedures that have been set up by the online marketplaces. And this is very much what I'm doing on a daily basis. So what can brands do to protect themselves? Well, without a doubt, the best way to protect yourself is to register your intellectual property rights. And Alison's already gone over this. That was a brilliant overview on how you can use various IP rights to protect your brand. And without a doubt, these IP rights are the lifeblood of every organisation. It will be your best events in the fight against counterfeiting. And once a company has gone to all the effort and cost of registering their IP, it's really important to do everything you can to protect it, but also to leverage it. So things as simple as storing your certificates in a safe place in an orderly manner. I can't believe how many of our clients have lost their intellectual property certificates or aren't sure about registrations. It's very frustrating when you consider the time and effort that they've gone into obtaining them. It's really important to remember to renew your rights, to pay your renewal fees, and to review your portfolio periodically to ensure that it fits within your current business model. Something that Alison might be able to talk to you about is the possibility of taking out IP insurance policies. Some of our clients have done this. When talking about your intellectual property, it's really important to get people to sign things like NDAs or NNNs in China, as they're referred to. And this will just give you a bit more protection when discussing sensitive matters. It's also really important to educate your employees about intellectual property rights. Yeah, awareness training can be effective in teaching employees about the value of IP, and it's also likely to reduce preventing IP leaks. So once your IP is registered, then it's quite important as well to advertise the fact that you've got those rights. So as Alison was saying earlier, you can use the R symbol when you've registered a trademark. This can be a really good way of sending a warning sign out to potential infringers that you've registered your IP and that you're prepared to defend it. But also make it difficult for people to steal from you. Make it difficult for people to steal your images, for example, by disabling the copy image function on your website. That's a really simple way of avoiding people just taking your images as easily as they could. And also make it difficult for people to copy your products. And this can be done by including secret features within the products. So there's some really sophisticated technology. Alison mentioned RFID systems. There's microscopic dots and stamp codes that can be included in packaging. Moncler use the RFID system, and Canada Goose have hologram stickers on their packaging and products, but it doesn't have to be anything that sophisticated. We also work with people who have something as simple as they have one thread which is a different color on the product to the rest of the cotton that's used. So you can be really creative with these ideas. So once you've put all of these preventative measures in place, the important thing is to go out and find whether you have a problem or not. And the easiest way to do this is to go and search online. The idea of searching online can be daunting. And so it's really important to focus your efforts here. Focus on the marketplaces that are most likely to affect you. Amazon is the leading online retailer in the UK and the US, so that will definitely be a sensible place to start. Focus on the channels with the biggest market share. Alibaba is the world's largest B2B e-commerce store and covers 80% of all online sales in China. If you have a problem with counterfeiting, it's very likely that your products will be for sale on Alibaba. You can focus on other notorious marketplaces. You can look at the list of these. There's 10 global platforms with the most counterfeits available for sale. Again, if you have a problem, they're very likely to be on these sites. But also in terms of focusing, think about where you're likely to be the most effective. Think about where you do have intellectual property rights to enforce. There's perhaps no point in going to look at South American sites if you're not going to be able to do anything in those territories anyway. So you want to be searching these marketplaces for your products, so using your trademarks, but also use common typos, use a variety of search terms, and think about translating those search terms, just using something as simple as Google Translate. And you can use reverse image recognition software. Again, images are so commonly used by counterfeiters. As Alison said, these people are often quite lazy, and using something like Google Images to do some reverse image searching will likely result in you finding counterfeits if they're out there. Now, there's lots of technology that exists for identifying and quantifying online counterfeiting, and most brand protection companies will offer you what's known as a free IP audit, so it's worth making use of this. If you find a counterfeit product, the best thing to do is to purchase one. Once you have it in front of you, you can do a detailed comparison between the genuine product and the fake. It'll give you really good insight into what you're up against. It could be a very poor copy, which is not going to fool anyone, but some of these products are very well made and indistinguishable from the genuine one, certainly to the unknown consumer. It will also give you ideas about how you might distinguish your product from the counterfeiters. So we have a client who decided to make their product glow in the dark, and they kept this a secret because this was a really good way of being able to identify it from the counterfeits. So once you've found counterfeits, the best thing to do is to use those online marketplace resources to have these products removed from sale. Again, it's about prioritizing. You can prioritize infringements by looking at the biggest offenders, look at those that are offering the greatest number of counterfeits for sale, look at the most highly trafficked venues, and just report them. Now, you do have to be careful about what you're accusing somebody of doing, so we would recommend that you seek advice from an IP expert in doing this. But if you're confident somebody is infringing your intellectual property rights, then use the mechanisms that are there to report these products for removal. It's definitely worth it. Most online marketplaces will comply very quickly. We have products removed within a matter of minutes, especially from Amazon. They're very responsive. And brands that vigorously fight and remove counterfeits will often see a dramatic drop in these infringements. A recent study found that nearly half of participants believe that brands should be responsible for removing counterfeits from the marketplace. So if you're doing this, then let your customers know that you're busy protecting them. Warn them about the dangers of fake and make it easy for them to buy the genuine products. You can provide them with a list of legitimate retailers and with a simple way of reporting suspects back to you in the form of an email address or a report button. You can call upon them not to fall for the appeal of the discounted price, explain to them that fake goods are not even worth the bargain price that they're paid for them, and explain to them you can tell them about the cost of producing products with ethically sourced materials made in factories with good working conditions, which justify the high price. Explain that quality, genuine articles are thoroughly tested at great cost and that such checks ensure the product is legal and can cause no harm. These are all things that might be obvious to you, but not necessarily to your customers. If you have a problem with counterfeits on the online marketplaces, it's worth considering a broader brand protection strategy rather than just delisting products. And this is where we would advise going to speak to IP specialists, because there might be more that you need to do. You might need to be monitoring domains. You might need to be ensuring that you don't have issues with brand impersonation. You might also want to consider those products that appear to be genuine, that are being sold by sellers that you don't recognize as being part of your distribution list. And you might also be wanting to consider offline strategies. These could be physical investigations, factory raids, and other activities. This is just some of the help that's out there. This first link is some guidance on how Brexit is going to affect intellectual property rights. But again, Mary and I will be here for the rest of the day, and do feel free to contact us if there's anything in particular that you want to discuss. In terms of the UK, the ACG is a great organisation, and on an international level, the International Anti-Counterfeiting Coalition have plenty of resource that can be useful for you. So that's pretty much it. So our parting message is that we understand that businesses have many ongoing battles, not least Brexit. There's also things to consider such as business and product development issues, manufacturing concerns, global logistics, and so on. But it's really important that intellectual property issues aren't pushed down the list of priorities. And the great thing about the OIA is that you're already here as one organisation, as one voice, and things like counterfeiting are so much easier to address when you're moving as an entire industry. So talk to those within the industry that are happy to be open about the fact that they've had issues with counterfeits. You can form partnerships with other companies, even your competitors. There are many companies that hold meetings with competitors and split the cost of investigators, lawyers, and factory raids. Yes, so the message is, and it's perhaps an odd message this week of all weeks, but together we are stronger. And so talk to each other and move as an industry. You'll be far more effective. That's me. Thank you.
Anyone got any questions for any of our three speakers in this area? Ralph.
Talk a little bit about passing on.
Okay. Yes, so if you haven't got a trademark registered, then you may have unregistered trademark rights. In order to prove a case of passing off, you have to prove you've got a reputation in something. So that might be any of the things that I talked about earlier that could be protected with a registered trademark, but it might be something you haven't got round to protecting. For example, slogans aren't often protected because they can be quite descriptive of what you're doing. Have a break, have a Kit Kat, should have gone to Specsavers. The Kit Kat and the Specsavers bit are fine, but the rest of it's a bit descriptive, so people don't bother protecting them with a registered trademark. So if you've got an unregistered right that you can still prove a reputation in, and you can show that somebody has misrepresented themselves as you, and you've suffered damage, then you can succeed with passing off. I think probably the best example of that was Asda tried to make their own biscuits, chocolate-covered biscuits, and they wanted them to look like the brand leader Penguin. So they called them Puffin. Well, Penguin and Puffin, yes, it's conceptually the same sort of thing, but probably if you saw the two words, no consumer is going to pick one up and not the other. However, an internal memo was found within Asda that said, make it look as close to Penguin as possible on the packaging. So they won on passing off because there was clearly they were trying to misrepresent to people that they were the other one. And it happens a huge amount in supermarkets, where the supermarket will make their own brand product as close as possible to the leading brand, on the hope the leading brand won't do anything because they don't want them to not stock them anymore. But it happens an awful lot, and it is another, because it's an unregistered right, it can be very flexible. If someone's taken what you think is the look and feel of your brand, but not the actual word, then passing off might be relevant. Is that...
So I was just going to say, there was a recent case with Patagonia and that vehicle thing. In America, where they basically copied the logo Patagonia, changed the font of the words and whatnot, and kind of pass off this beard.
Yeah, so passing off is a very British thing, but the Americans have unfair competition, and the rest of continental Europe has similar dilution, that kind of thing. So the actual terminology might be different, but yeah, if you're benefiting somehow.
I think they were part of Budweiser or something like that. This
Oh gosh, they should know better. They should know better.
Question there next to her.
Yeah, so it's an interesting point you say there about if a supermarket brand is trying to sort of appear to look like you, you're very unlikely to challenge them. So what would you recommend that a brand does in that situation? Because you don't want to not be stocked by said retailer, so you don't want to have a fight with them, but at the same time you don't want them to rip you off.
So obviously it depends on the specific relationship and the specifics of the case. I would still recommend you send a letter and let them know that you're not happy, but there's usually a way of negotiating. So you might suggest something you do want them to change, like could they just change the font or the colour or whatever. I think it used to be more prevalent than perhaps it is now. If you've got evidence of actual confusion where a customer has picked one up and then complained to you or complained to the supermarket, whatever, that's going to help your cause that they are actually damaging your sales rather than just that's what all the products look like in this category. So, but usually there can be a way of just saying, well, okay, look, can you change something, some aspect of it that we really think we do own, but the rest can be the same. So it's usually negotiation is going to be a better route, but yeah, it's not going to be an easy one. And that's if you're the big brand. If you're a small brand and you've only just started being stocked in a supermarket, you've got a much harder mountain to climb to persuade them that actually they should listen to you. If you've got registered rights, that's going to be putting you in a stronger position because you haven't got to worry about passing off then. It's straight trademark infringement and they probably don't want to be having that go through the press.
Anyone else? Yep, Noddy. Yeah.
You all mentioned the whack-a-mole process of getting things taken down off marketplaces. In specific to sort of the Chinese counterfeits that we're seeing in the PPE market, have any of you guys had experience of taking it further than taking it down off marketplaces and going straight after the perpetrators?
So there's no doubt that there's an element of whack-a-mole in what we do, but in recent years the online marketplaces have taken that on board and they've implemented ways of shutting down accounts and banning individuals altogether from selling on these marketplaces. So Alibaba is a great example. So they have a company policy. So Alibaba own 5 of the biggest online marketplaces in China. And they have a company policy that you can infringe 3 times and then your account will be shut down. And now they've started connecting, registering accounts with identification cards. So a person has to be named when opening an account. And if that person tries to open another account, they'll be banned. So there are systems in place to try and stop that whack-a-mole system. We haven't... So sorry, your question was taking it further?
Yeah, if you're taking proceedings further than dealing with the marketplace and going straight to the main offenders.
Yeah, so that's probably something that if you've got your rights registered, you then take it to court. And it's a very strange situation in China, and I don't have a great deal, I haven't been there, but in terms of their legal system, I think it's done by local sheriffs. So we act for the International Youth Hostel Federation, and they had a problem with people springing up using the blue triangle and passing themselves off or infringing the trademark, saying that they were registered youth hostels. And if you've got the registered right, which we did have, the local sheriff just went and shut it down. So they do have quite, I think it depends on the region, they can have quite strong powers. Now, of course, it's still whack-a-mole because they might pop up again, and it's easier with it bricks and mortar than it is online. But a concerted effort is definitely something that helps. And having the right representative in China to do it for you, who's got clout with the right people, and who can do things efficiently rather than whack-a-mole, who know they do. There's a firm of attorneys we work with who will look at further up the supply chain. They will do the investigation. Now, it comes at a price, but they can do that and find out. And also, they're starting to get situations where there's more of the case law is online, so they can find out that this director is known to be somebody who does this to lots of other companies, and that obviously improves your chances of success. But it's such a vast country with so many people, it isn't easy.
Certainly, I think the only thing I would just add to that is that leaving things unchallenged is worse than the whack-a-mole. Because I sometimes use the analogy of a gardening scenario where you go into a very wild garden that needs a lot of attention, you tackle it very aggressively, and you're then left with weeds that will be popping up without a doubt, but they're much more manageable to take care of. So the other side of it is the gathering of the evidence. If you've got the online monitoring going on, evidence can be gathered either just with your brand and product range or collectively, as Jet said, with others. And that's where evidence coupled with trap purchasing or test purchasing can start to be collected, and then working with legal teams can affect change offline.
And things are changing in China as well. I think that it was true that for a long time it was a territory in which there wasn't much respect for other people's, certainly IP that belonged to companies from other countries, but things are changing now, and I remember reading that now there are more cases within the Chinese IP court that are from one Chinese company to another than from a Western company to a Chinese company, so I think things are changing a lot.
There's a time that we need to be out of RGS. So, Simon, I'll come for you for one last question. But we will be putting all these slides up. These will go on the OIA website because it's slightly different because it's primarily counterfeit. So you'll just go onto your normal OIA website and you'll be able to download that and get all the guys' contact information for all three of the guys. And if you wanted to ask any sort of brief questions around this, I'm sure they'll be happy to email you. And if you want them to act for you, obviously you'd have to engage them, but that's what they're there for. And I know Richard, they've done some work for you in the past for Little Life. We did take some references up. They've done quite a lot of work in our field generally, and they were very well thought of, which is why we asked them to speak for us. But don't go to the Get Ready for Brexit website and expect to see this one. So this one will be on the OIA one. Everything else will be on the Ready for Brexit. So we've got about half an hour, but so if you wanted to come up and have a one-to-one with any further questions, if that's okay, then do that. But it just means we can start clearing the room up and get ready for the camera guys and the IT guys to go. So I think big round of applause for these guys. Thanks very much.